Alex here with part 160 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Also, with every 10th video, I like to remind my viewers that if you are not getting all of the notifications on the My Docket series, it's probably because you are a subscriber, but you have not clicked on the bell notifications button. If you do click on that button, YouTube will notify you of each and every single one of the publications to the series rather than just the ones that they think you want to know about based on their algorithm. This is a video where we start to see my ex's attorney's opposition and what I want to call her angle. I'm not going to talk too much about this because this is more guesswork than usual with me. Usually I have a pretty strong opinion as to what my ex was thinking, depending on the point of the case. But this time I'm slightly leaning towards this, but I'm not 100% sure as I am, or at least can never really be 100% sure when you're guessing what somebody's thinking. But I at least am a whole lot, more convinced of what I am, I guess you could say, speculating as to my ex's thoughts. In this particular situation, my strong suspicion is that my ex wanted to use this as a basis to show people that I was a bad person. She did not pay the 50. So as I start to think about what I'm going to tell you guys, it becomes more obvious to me why none of this makes any sense. So not only did she not pay the $50 a month towards the judgment, she didn't even pay the child support amount. And if I remember correctly, she hires this attorney, and this attorney sends a letter to my attorney, and he says, "Hey, I have the $50 for you." At the time, my attorney contacted me, and I was like, this isn't in good faith. Number one, it's just $50. Why didn't she pay it on time? Number two, if she really wants to show that she messed up and she's trying to fix the problem, why is she only paying the $50? Why isn't she paying the full child support amount? If you guys can remember, the full child support amount is around like $580. So a letter from this attorney should say something like, "Hey, my client just hired me. She's really sorry about being late. Here is $580 plus $50. Instead, what he does is he says, "Here's $50. Please don't send out that writ of execution and don't subject her to a debtor's exam." So to me, I'm thinking that she deliberately hasn't paid any of this stuff at all. As usual, this is what she's done. I mean, if you guys remember the hearing video, you'll know that she was 13 months in arrears. So over a year, she didn't pay child support. And her attorney is like, "So to stop this execution and debtor's exam, here's what you have to do. Send them $50. That's it." So this was, to me, very obviously an angle. It's an angling. It's just a strategic decision. Doesn't care about best interest, doesn't care about good faith, doesn't care about trying to heal. It's just, how do we stop Alex from subjecting you to a writ of execution when you haven't paid a dime? Here's how we stop him. Send him $50, which is insulting, not necessarily because of the low amount, but it's because it's as if he's asking us to completely forget the history of the case and to pretend that she doesn't also owe $580 on top of that. I'm trying to recover all of this money. I've taken out credit cards, I've taken out loans, and I'm trying to pay all of this back. I have judgments against my ex, and she sends me $50 late. And that is infuriating to me. And I tell my attorney, no, this is just a sham. She is only trying to take this simple issue and turning it into yet another conflict. If she would have paid the $50 prior to the time running out, would I have filed any of this stuff? No, I wouldn't have. If she would have said, "You know what, I'm not going to pay you child support. I'm going to just pay you $50 so that you can't execute," I would have been like, "Oh, well, I'm stuck. I mean, the judge said she gets 30 days to pay $50, so there's nothing I can do." Why would I say that? Because I'm not an attorney, and all I know is the statutes and the court rules and the court orders. And Right and wrong and morals and ethics don't matter. What matters is, did my ex comply with the order? It said pay $50. Yes. What am I going to do? I can't do anything about it because she complied with the order. So as I've stated in the previous portions of this video, my ex deliberately won't comply with the order because that creates more conflict. She wants me to file something. She wants to portray me as an evil person. And that's exactly what I did. She didn't pay any money at all, not child support, not $50, nothing. So I filed a writ of execution, which you guys saw in the last video. I also filed a motion to subject her to a debtor's exam. And I felt like I was completely in the right because of her history, of her past. This is not like we're in year 1 and everything is, still kind of tense. We're in year 2015. We're about to get to 2015. So year 8, 9, 10, 11, 12, 13, geez. From 2008, that's a lot of years. We are knee deep in this case. And so I felt that I was complying with the law by proceeding on execution. And ultimately, I was complying with the law because the Supreme Court would back me up on this. Unfortunately, this attorney ends up winning short term because I do file an appeal and I get it overturned. But this attorney ends up winning. The letter, for whatever reason, successfully dupes the judge into violating the law, which is what she does. The judge will make a ruling on these motions that are coming up and these oppositions based on her personal opinion. And this is one of the things that is really unfair about the family court system. We are parents. We don't know who you are. You're wearing robes, you're sitting on a bench. We don't know what your opinions are, what your ideas are. We don't know any of this stuff. The only thing that we have to go off of as parents is statutes, rules, and case law, as well as the advice of an attorney if we have an attorney. Honestly, the attorneys should be doing the same thing. But what's happening with these family division judges is they're basically ignoring the laws and they are inventing their own rules out of thin air. They're just creating these rules and they are based on their opinions. And so what you have is these different judicial departments, each of which is a law unto itself, because each of them has different opinions as to what they want people to do. And they expect you, the parent, to read their mind and figure that out. If you're a lawyer, they expect you to figure it out over time. You're in front of that judge for 2 years. You kind of figure out what they want you to do and what they don't want you to do. Nobody follows the law anymore. Everyone just does whatever the judge wants. This is completely not what the legal system is supposed to be like, and it's not what the legal system is like in other areas of the law. For whatever reason, I think it comes mainly from the lack of appeals and also from the fact that the legislatures, at least of this state and other states, haven't given them too much latitude. They've given them so many areas of discretion that they've just gotten to the point where they just think they can do whatever they want. So I think these two things combine into that. In any event, the judge reads the letter and thinks, oh, well, this is reasonable. He was going to send Alex $50, so Alex is an evil man for doing this. And so the judge rules against me, imposes sanctions. I file an appeal. The Court of Appeals is not amused, overturns the judge's decision, says she abused her discretion, etc., etc. The Court of Appeals is going to come down pretty hard on the judge, which is good because I think more judges need to knock it off and actually follow the law. That's what they're supposed to do. But we're going to get into all that stuff way into the future. For now, I just wanted to let you know what my mindset at the time was going into this document. One last thing that I want to mention is, if you watch my video, the judge does not remember you. This kind of conduct from this judge is what led me to create that video. If you look back at part 152 of the My Docket series, you'll see at the hearing that the judge said that she has become familiar with the case and she read the documents, blah, blah, blah. She didn't. She hasn't read anything. And it's not just because of this $50 shenanigan that I say that. The main thing that convinces me that this judge didn't read crap is that she actually orders us to start changing clothes again. And this is the biggest reason that I created the video, The Judge Does Not Remember You, because they don't remember anything. They remember this kind of fuzzy notion that you guys are annoying and you keep coming back to court, but they don't remember any of the details. Otherwise, she wouldn't order us to start changing clothing again. Once we start changing clothing again, clothing thefts start again, motions get filed, and she eventually realizes she's a knucklehead and she reverses her own decision. But all of this stuff is going to come out now that I have a new judge who has no clue what's going on with any of the history of the case, and most of her mistakes come from her ignorance as to what's going on in her case. Rather than trusting the filings and paying attention to the documents that I filed, she just comes up with her own fuzzy ideas as to what she thinks is going on because she kind of thinks we're new because we're just now in front of her. She doesn't realize we have a long history of these issues. And she's going to learn the hard way when the Court of Appeals overturns her decisions over and over again. So with all that being said, let's go ahead and take a look at what my ex's attorney has 5. Here we have my ex's attorney's opposition to motion for supplementary proceeding in the aid of execution. Starts off with a standard introductory paragraph, introduces my ex, indicates that he is representing her, and that he is opposing my motion to subject her to a debtor's examination. He's also asking for an award of attorney fees and costs. And this is the thing that I have mentioned is, in my opinion, is one of the most evil things that these attorneys do. And the reason why is because this is what they use to financially break your back, to get you to stop coming back to court. And I think that this is one of the things that facilitates abuse and neglect in high conflict cases. These parents are basically told that if they don't go away, they will be financially annihilated. And that's the message that these attorneys send them. I don't think that they really care because they're rich. Most attorneys, they've gone through law school, they start to make a whole lot of money, and they don't really understand the plight of the common person. All of this stuff, you know what, I mentioned this in 2 different videos, so I'm going to go ahead and stop here. The first video, take a look at the video, Defend Against Attorney Fees. The second video that I would say to take a look at is titled, Why Attorneys Don't Understand. It's something like that. I might have not got that title perfectly right, but I do explain why attorneys like this really don't understand us or where we're coming from, nor do they care. The portion of nor do they care comes up mostly in the video, Win at All Costs. Going into the next page, he signs the document. Next page, we have the factual background. So in the first summary paragraph, he is indicating that this judge has granted my motion to give me unpaid medical and dental expenses, as well as interest in the amount of $289.82. He is also indicating that I was awarded child support arrears in the amount of $960. All of this is true, and that my ex was ordered to pay both of these judgments in the amount of at least $50 per month. Here he mentions that I filed my motion for supplementary proceeding in the aid of execution, complaining among other things that she has not begun paying her $50 as required by the order. She's also not paying child support. Same thing. Next section here is that my ex provided me a check for $50 on December 23rd. Hey guys, when was that hearing? That hearing was on November 4th. So she sends me a check over a month late. And I could understand, guys, if I was wealthy, but this is not what happened. I had to get my son through a surgery, and that cost me multiple thousands of dollars, credit card debt, interest was accruing, loans, and I had no reason at all to expect that my ex was going to pay any of it. She hadn't paid anything for over a year. So for me to see that she wasn't paying as soon as that month was up, for me to take immediate action is completely normal and to be anticipated. The fact that she paid $50 over a month late and that ticked me off, I don't think that should be a shock to anyone, certainly not the judge. But for whatever reason, the judge is not on this planet. She's in some other dimension where she just doesn't have a clue what's going on with this case. This is seriously why I constantly tell people the judge does not remember you, and to really embrace the fact that they just don't know what's going on, and you have to take full control of your case because these people don't have a clue. I'm going into the next section. Discussion. Motion for supplementary proceedings should be dismissed, and I should be responsible for my ex's attorney's fees and costs. He goes into the law, Nevada Revised Statute 125-240, which grants the district court's broad discretionary authority to enforce its orders before or after judgment by any means, quote, it deems necessary, unquote. The Supreme Court rejects this opinion. I don't know where he's getting this from. It's like he just took a random statute and he used these 3 words, it deems necessary, to make it seem like the family court can do whatever it wants. This is not at all what the Supreme Court nor the Court of Appeals thinks. It's a nice tactic by him, and I think it does effectively dupe this judge into believing him, but it's not going to work. He also cites Lamb v. Lamb and Charts. Neither of these 2 cases are applicable. The Court of Appeals is going to reject both of them. This idea that the court has an inherent authority to maintain control over proceedings before it is true, but that has nothing to do with what we're talking about. Inherent authority has to do with the ability of the court to schedule things and control how proceedings are conducted. It does not give the court the authority to violate the law. And this is something that actually came up pretty recently on Our Nevada Judges. I think it was Well, recently in terms of law. Recently in the context of law could be as much, as long as a year. And anyway, a judge said that he could do what he wanted because he had the inherent authority, blah, blah, blah. And he cited Young v. Ninth, and the Court of Appeals rejected that. And they said, you have to comply with the law. What you're talking about has to do with your ability to manage your staff and your timetables and stuff like that, your calendar. It doesn't allow you to just say, I'm going to just do whatever I feel like it, and to hell with the law. He goes into NRS 21.270 subsection 1, which states that, let's see here, a judgment creditor at any time after the judgment is entered. Okay, this is actually favoring me. Okay, so he here is citing NRS 21.270 subsection 1. This is a law that the Court of Appeals does cite, but they use it against him. So this citation to law is going to be used against his own client and in my favor. When you see the order reversing from the Court of Appeals, we'll talk about NRS 21.270 subsection 1 and why this favors me and not him. I requested that I be permitted to examine my ex as a judgment debtor under the law as a result of her failure to begin making the $50 payments. My ex has since began making the payments. He doesn't mention that it's late, but it's late. We'll talk about this on my reply to opposition to motion. As the court is well aware, the primary purpose of the law is to permit a party who has been awarded a monetary judgment to question the debtor about his or her assets in order to determine how the judgment may be satisfied. In this matter, there is no mystery as to how the judgments are to be satisfied. The court specifically ordered that my ex pay $50 until the judgments are satisfied, and that my ex has begun making the payments as ordered. There's simply no reason to permit blah, blah, blah. So you see here how at the bottom he says there is simply no reason to permit. This attorney is making a huge mistake. I talk about this in the video Fairness versus the Law, and I also talk about this in the video Custody by Morality. These general overarching principles of fairness, right and wrong, do not control the outcomes in these cases. What does control the outcomes is statutes, rules, and case law. Take a look at that video. It's a lot better. It's going to give you better guidance on how to deal with attorneys like this. In that video, I explained that what controls the outcome is NRS 21.270 subsection 1, and this is what's going to cause me to win and him to lose. Next section here is, indeed, the parties are each submitting financial disclosure forms following the last hearing in this matter. So what he is trying to say here is that the financial disclosure form in and of itself is what satisfies any need that I have for the debtor's exam. But this isn't true, and the Supreme Court isn't even going to talk about this because it has no merit. The purpose of the financial disclosure form is for you to voluntarily disclose information. The purpose for the debtor's exam is for me to force you to disclose information that you don't want to disclose. They have two completely different purposes. So again, you notice that he's not mentioning any statutes here. He's just trying to say I'm harassing my ex. Just because he's saying that doesn't mean it's true, and without any evidentiary support, he's not going to get anywhere. The Court of Appeals is going to specifically say that. He can't just use the word harassment as a label, similar to how my ex is doing. If you guys take a look at I don't know what video it is I explained this, but I have explained that attorneys, okay, so what I've explained is that high conflict exes find attorneys like this that will echo their statements, or what I sometimes call mercenaries. They're going to do whatever it is that they're told to do if they're paid to do it. And that's why you see that this attorney is using the word harass, similar to the way that my ex is using it. He's basically saying, if you pay me money, I will say what you want me to say. And unfortunately, it does work because it dupes this judge into violating the law. But again, don't worry about that because I'm going to correct it on appeal. Next section here is, initially, I filed my motion for supplementary proceeding when my ex owed me $50 towards the judgment. Currently, she is current on her judgment payments. She's only current because she paid late, and she will continue to remain current. Now, this is funny because she doesn't. So after the judge denies my requests, strikes my execution, and sanctions me, you would think that my ex would continue to make the $50 payments towards the judgments. Newsflash, she doesn't. She stops. As soon as the judge strikes the execution and as soon as the judge denies the motion for debtor's exam, my ex stops paying, because that was the whole point of it. The whole point of her making the $50 payments was to make me look evil and to stop execution. Once execution ends, the payments end. And this is one of the reasons why parents like us become so furious with this legal system. And this is one of the reasons why I constantly tell my viewers that the legal system is pervaded with incompetence, because they don't really care. The ability of the judge and the attorney to see into the future is so short. They're very short-term thinkers. They're very episodic in how they handle these problems. Alex got $50. I'm denying the motion. The end. And then they don't realize that my ex is going to say, cool, that's exactly what I wanted. Now I'm going to stop paying him. They don't understand that. That to them, that's a foreign concept. To us, it's like, guys, what are you thinking? Anyway, let's move to the next section here. Request for attorney fees and costs. Pursuant to 126-171, the court enjoys the discretion to award reasonable fees of counsel and other costs of paternity actions and pretrial. What? This is not a paternity action. Where's he getting this from? Oh, I see what he's trying to do. Okay, so now my opinion has changed. So originally I thought that this attorney just didn't know what he was doing. He's citing a law that's in a completely different statutory scheme. Okay, so at this point in time, I have changed my opinion. This attorney has gone from not really knowing what he's doing and making a sincere mistake to deliberately confusing the judge. So statute 126.171, that's not applicable to our type of lawsuit. I believe that he's pulling that out of the paternity action lawsuit. This makes me convinced that he knows what he's doing and that he's deliberately trying to confuse the court. So statute 126.171 is patently unapplicable to this case, and I think that this is one of the statutes that the court erroneously relies upon in granting my ex-attorney fees. We're going to take a closer look at that when we actually get to the court's order. The Supreme Court of Nevada doesn't even look at that statute because it's completely wrong. Next section here. The Supreme Court has indicated that in family law matters, the court must evaluate the request for attorney fees based upon the factors articulated in Brunzel. That's true. But Brunzel doesn't talk about whether or not you're entitled to an award. Brunzel talks about how much you're entitled to. And I think Miller v. Wilfong is the domestic relations matter component of that. And I think that talks about making sure that you look at the ability of parties to pay fees. I might be wrong about that one. I'm not wrong about Brunzel, though. Brunzel is an applicable case. He is right about that, but it only talks about the amount of the award. It does not justify the award, and that's something that I will address on appeal. In this matter, I have requested that I be permitted to examine my ex as a judgment debtor on the basis that she has not begun paying the $50 per month as ordered by the court. First, she began paying $50 per month as ordered. That's not true. She began late. And then the entire point of examining a judgment debtor is moot in this matter because the court has already determined how the judgments will be satisfied, and that's just completely wrong. So none of this stuff is going to be taken seriously by the Court of Appeals. They're going to consider all of this to be meritless. Next section here is conclusion. I've been awarded 2 judgments against my ex. My ex is paying towards those judgments, which she's not. And it's sad because now these judgments, I'm not going to be able to collect them for another year because the process is going to be slowed down so badly by this judge's incompetence that she is literally exacerbating the damage inflicted by my ex upon me. So she talks at the hearing about how shame on my ex for not paying all that money and not paying child support for a year. And then she goes and enters an order imposing sanctions, which basically enables my ex to not pay any of that money for yet another year, which means that the credit card debts that I have and the loans are going to continue to go on for a whole nother year because of this judge's pointless entry of sanctions in this case. These attorneys are really good at duping these judges because they have strong relationships with the judges, and they exploit that. The judges often don't pay attention to the facts of the case, and what they instead do is pay attention to the attorneys and whether or not they trust the attorney, which it basically enables the attorney to confuse and deceive the court. Going into the next section, we have the affirmation under the law, which states that I have not... what's going on here? Oh, there's no social security number attached to this document. Sorry, this is not my filing. This is his filing. So this is James Barnes. Now I know, I think I mentioned in the last video that I wasn't sure which attorney is the attorney that actually is going to appear consistently through this case. And I am sure now that it's James Barnes. Going forward, I'm going to continue to use his photo because as far as I know, he's the one that files everything going forward, and he's also the one that appears at the hearings going forward. Next, we have Rule 5 Certificate of Service indicating that this document was mailed to my attorney. And then we have the motion opposition notice. I do believe that he doesn't have to... Oh, no, wait. Hold on a second. Final decree has been entered. It's on a... If yes, then continue to question no. So, okay, so this doesn't... Okay, so this indicates he did not have to pay a $25 filing fee. We have the list of exhibits, which is a letter. Exhibit 1. And here's the letter. So here he's telling my attorney, please be advised that my client has retained our office in this matter. We filed a notice of appearance to memorialize our representation. Reviewed my motion for supplementary proceeding in hopes of avoiding costs have included our firm's check number in the amount of $50. And so here's the $50 which satisfies the monthly payment. Please give a call, blah, blah, blah. So I very strongly believe that this letter is what caused my judge to make the mistake that she made. She read this letter. She thought, hey, this lawyer's being reasonable, and she wanted to punish me for being unreasonable. She didn't pay attention to anything else in the case. I think that this attorney looked at this judge looked at this one letter and made her entire decision based on this letter. And this is what caused her to make the mistake that she made. And this is what makes it so easy for lawyers like this to get away with things, because they don't really need to comply with the law. They just need to find out what it is that this particular judge wants to see, and they just give that judge that particular thing, and they're able to get the outcome that they want despite the law being contradictory to what it is that they're asking for. I think that's everything. Enclosure A, no, we have the check for $50. He sent it to my lawyer, and that's that. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex, her attorney filed one document, but it was a free filing, so she incurred $0 in costs. My attorney was representing me for free, so I incurred $0 in attorney fees. My ex's attorney spent some time on this opposition. I do believe that he would have charged her. I imagine that the amount that he charged her to file this He would have had to communicate with her. He would have had to get some of the background of the case because he's a brand new attorney. It's a substantial document. It's not very long, but it's also not short. I do think that it's reasonable to think that it took him about an hour to prepare this. At the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.